Counsel?
Hi. Good afternoon, Judge. If I could have 2 minutes for rebuttal, please.
Certainly.
If it please the Court, Deborah Jesse, Legal Aid of Buffalo, for Anthony Parson, Jr. My colleague agrees with me that defense counsel advanced a two-pronged strategy at the suppression hearing. However, that two-pronged strategy was unreasonable. The adversarial process was denied appellant by the totality of the representation, and counsel evinced a lack of command of the law and a misunderstanding of the facts.
Do you know of any case where some defendant has been convicted that it's because his lawyer failed him? I'm being a little facetious, but I mean, things happen in the course of a trial that happen, and we're saying, well, the totality of the circumstances, he got convicted, and they could have done a better job. I'm wondering where the standard lies, if we would agree with you.
Well, Judge, I think certainly people get convicted, and when we look in hindsight through the prism of hindsight, we can look and say, well, counsel could have done this, counsel could have done that. And this court has said repeatedly, people are not guaranteed a perfect trial. They're guaranteed a fair trial. But in this case, the standard is reasonableness, and it's whether or not a reasonably competent attorney in this same situation would have advanced the same process that this attorney advanced.
Well, what was unreasonable about it, counsel? I'm trying to figure that out. I
Well,
mean,
the
he asked questions of the officers, and they seem to be pretty pointed questions about the windshield. Don't you think that perhaps if they had asked more questions, they would have, maybe undermined some of the vagueness of what the officer was talking about?
I don't think so, Judge. I don't think that there was any possibility of greater harm falling to my client by asking more questions. As a matter of fact, specific to the Engle part of the hearing, which is the initial stop of the traffic vehicle, at the very outset, before the hearing even commenced, counsel misstepped by not requesting the Engle hearing in his omnibus motion. So he didn't request the Engle hearing until the day he showed up for the suppression.
Well, it's a rare hearing,
Pardon me?
too. It's not a common hearing. It's not in your normal omnibus that you've got in your word processor, an Engle hearing.
Perhaps, Judge, but it's still incumbent on counsel to know the facts, marshal the facts, and have the appropriate defense.
Well, he did actually get an Engle hearing, though, before the hearing started. So,
He did.
yeah.
The judge didn't specifically respond, but the two officers were called, Officer Humiston and then the lieutenant. But at the hearing, after the Engle hearing, that portion of the hearing started, it was really incumbent upon defense counsel at that point to enlarge and expand the record.
Is there anything in the record that shows that there would have really been any reasonable possibility of success in arguing for suppression?
Specific to the Engle issue, Judge?
Well, specific to the stop, yeah.
We don't know. I mean, we can only speculate. Maybe not. We don't know that, but that's not the standard for this court. The standard is whether or not the approach was reasonable.
I'm not
But
sure
don't
that's
we
true.
need- I'm sorry.
I apologize, Judge. We're going to say in every case with what the defense lawyer did, was it reasonable or not, and make our own subjective determination as to whether it was. I can picture in this case talking to your client, if you're the defense lawyer, and he's cooked. I mean, he wants to say, it's not my coat, it is his coat. He wants to say, I'm taking this position, and it's not true. So he's left with two deuces, and he's got to do the best he can for his client. And we're going to say, well, because you didn't do more, the guy gets, we start all over again. I just don't know where we interfere with an attorney-client privilege in terms of what the attorney may have known.
And if it were an attorney-client privilege and he interviewed his client and he got bad information, you're correct. He wouldn't necessarily be ineffective. But in this situation where he looked at the testimony that came out of the direct, and he basically forfeited the opportunity to enlarge the record and get any good information.
What would you want to
for his
enlarge
client.
it with? I mean, maybe what the officer said was true.
It could have been true, but there could have been other truthful information that would have helped his client. Specifically, he just took the answers given on direct and he turned them into questions.
But when you say could have, I don't mean to pick on you, when you say could have been helpful, that's not our standard. We don't look at the record and say, you know what? You know, if we had a better defense lawyer here, you know, one of the top ones, this case wouldn't have gone the way it did. So obviously, this guy's incompetent. You know, he's ineffective vis-a-vis, you know, someone else, and therefore we're going to reverse this conviction.
Well, that's not the only issue in the case. No, if I could, if I can move on. The 71030 inculpatory statement, when that came out during the hearing, that was the opportunity for defense counsel to object. Not just to object, but to ask for preclusion and excise that statement from the people's case in chief. Yet counsel sat absolutely silent. He didn't.
He said, Judge, that's only part of the statement. I don't think that was all of 71030. And I recall, as I recall, the prosecutor said, that's right. I have another witness. I'm going to bring out some more 71030 statements and through another witness.
Judge, I think what happened, first of all, it was at the end of the testimony. He didn't say anything initially. He allowed that information to come in, which then led to more harmful information coming in that then there were a lot of questions about, well, what did you ask, or what do you think you asked, what do you remember?
Does 71030 apply in the suppression context, or is that preclusion at trial?
It's preclusion at trial, Judge, but it certainly would have undercut the defense's case at this point. In the suppression hearing, of course, the goal is to suppress the drugs, the inculpatory statement, and the gun, but it also could have bolstered his position to perhaps get a plea bargain. And maybe in this case, the only plea bargain he was going to get, the only benefit he would get, could be a sentencing commitment. But he didn't even have that.
How would it have affected the trial, though? I mean, there was no charge of marijuana possession.
Correct. It was a violation level amount.
Okay, but there was no, he wasn't even charged with it. And the police officer testified that he smelled burnt marijuana. So even without the statement, wouldn't that have given him probable reason to search the vehicle?
Well, that is what the appellate division said, Your Honor. However,
Well, I'm asking you.
Chestnut, which is not yet stale, Chestnut tells us the original wording from Chestnut when this court issued a very short affirmance was based on two trained police officers. They were specifically trained in the detection of narcotics by olfactory senses. So they were trained in smelling marijuana. In this case, there was no record evidence that this officer had any training in that area.
Well, there was evidence, if I'm not confusing another case, but he was an officer he wasn't a brand-new officer. He had been an officer for 11 years. There was at least that evidence, right?
11 and a half years. That is what they said,
All right,
Judge.
so maybe it might have been dangerous to ask questions about what his experience was because he may have elaborated and shown himself to be eminently expert in detecting the smell of marijuana.
He could have, Judge, but that wouldn't have left this person, my client, in any worse harm. When the court ultimately, distracted by my light, I'm sorry, when the court ultimately issued their decision at the end of the suppression hearing, the judge actually wove that information into their reasoning. The fact that the officer approached, he rolled down his window, he smelled marijuana, he asked him, there was an inculpatory statement. So it was harmful. There was prejudice, Judge.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. Ashley Lowry on behalf of the people. In light of the proper police conduct in this case, where defense counsel presented two rational theories for suppression but was ultimately unsuccessful, he's not ineffective. That is not the standard that this court has upheld. My opponent asks this court to speculate that a more vigorous cross-examination of this particular witness would have undermined his credibility, and that is simply not the standard. This is not a clear-cut, dispositive Turner error. This is not a situation where any, particular question or error or omission on behalf of counsel would have changed the outcome of the proceedings here. And we have proper police procedure from start to finish. Here, the police had probable cause based on two
Well, I think the
separate-
dissent in the Fourth Department were pointing out more of what the defense didn't do than how the police testified. I think Judge Fahey was pointing out that there was just total deficient. He could think of, I think in a short period of time, a number of questions that were obvious that should have been asked that would have led to perhaps, as counsel's saying, a suppression.
Well, first of all, that is all speculation. We do not know what the outcome was. However, defense counsel did cross-examine where there was something to cross-examine about. They did ask about the reasons for the stop. He did ask about the police officer's ability to see the violations, especially consider the lighting conditions, the speed of defendant's vehicle, the direction of travel of his vehicle. Based upon those positive responses of proper police conduct, defense counsel tried to minimize the damage of that and still make that
Did his
argument.
questions add anything that the direct testimony didn't
It did
already state?
expand slightly. However, when he realized that the police officer was not getting caught up in his cross-examination, he was not, undermining that credibility, he directed his questions, he took his questions in a different direction.
You seem to be suggesting, counsel, that this lawyer did the minimum to avoid being ineffective. So, where do we draw the line if it's, how do we decide what's the bare minimum and what's not?
This particular defense attorney represented the defendant from start to finish. He was there making bail motions. He did, provide motion papers. He did make the request. He did, provide two rational theories for suppression. He fully litigated the voluntariness of the statements as well as the circumstances surrounding the stop. He did what he could within the facts of this case. And then at sentencing, when defendant did ultimately decide to plead guilty, he received, he argued on behalf of the defendant, he received the minimum incarceration, he received the minimum post-release supervision. So I would say this counsel, based on this record, is more than effective. It's a matter of fair, a fair suppression hearing. It's a matter of meaningful representation. Did the defendant receive a fair hearing?
Speaking of the fairness, why didn't the people give 7-1030 notice on all the statements?
Obviously, it would have been better practice to have included that particular statement. However, the remedy would have been preclusion of its use at trial, not its, not our introducing the statement for purposes of the probable cause analysis at the suppression hearing. The officer's testimony of his personal observation of the smell of marijuana, that would still be allowed. It would be only his statement that would have been precluded at trial. So it really wouldn't have changed the outcome. Unless the court has any other questions?
Thank you.
Thank you.
Counsel?
Counsel's errors and omissions couldn't have been strategic. The fact that he didn't object to the unnoticed inculpatory statement, there is simply no excuse for that. It would have minimally drawn the court's attention to the fact that this veteran officer was offering testimony at the suppression hearing that conflicted with his written record evidence in the case.
I don't disagree with you. One of the things I look at, I'm sure you've seen it more often than I have, where defense counsel's just kind of walking through the, just going through the motions, mainly because they know the client's goose is cooked, but you still, want to do that. Is that what this argument boils down to? Is that he didn't get deeply enough into the case?
I don't think he was alert. He wasn't paying attention. As soon as that statement came out, any reasonable attorney would be set afire. I can picture the typical courtroom where somebody stands up and makes a lot of noise. And even though the remedy is preclusion from the case in chief,
Not a
it
bad
certainly
remedy.
would have alerted the court to the fact that there was some conflict in the case. And perhaps it would have undermined the credibility of the testifying officer. Additionally, another piece of counsel's argument that was
And the conflict that would have undermined the credibility of the officer? I'm not following that point.
the fact that he didn't document the inculpatory statement. There was no written documentation of that, but yet he chose to testify to that at the suppression hearing. The record didn't match the testimony. Additionally, counsel did make an argument that this was a pretextual traffic stop. And as we know, this court instructed in Robinson that pretextual stops are lawful if they're supported by probable cause to believe that a motorist violated the vehicle and traffic law. So that was a misapprehension of the law. We're just asking this court to consider that Mr. Parson did not receive the effective assistance of counsel to which he was entitled, and therefore he was denied a fair adversarial process.
Thank you.